So just to start, my name is David DeFelice, and I'm from Duquesne University. You can come up. So you can introduce yourself.
Hey everybody, my name is Aaron Hill. I'm from the University of Pittsburgh.
So we're both actually from Pittsburgh, Pennsylvania, or at least go to school in Pittsburgh, Pennsylvania. So to kind of just frame today's debate briefly is that we are going to be discussing Derek Bell's theory of interest convergence, which in essence, it's talking about how African Americans can only achieve social justice by convincing whites that reform was in white interest. Under this view, efforts to promote awareness of injustice, for example, are far less important than efforts to promote white perception that social justice reform is in their interest. So just briefly, we'd like to just poll everybody to see where they're at. There's only a few people here, but still just to see. So if you are supporting the resolution that social justice movements should use interest convergence theory as their primary method of criminal justice reform, if you could just raise your hand. Okay. So we have two. Okay. All right, two. So anybody who disagrees? Anyone who disagrees? Sure, just for argument's sake. Okay, so we'll say it's 2-1. All right. All right, you'll abstain. All right, that's fine. Okay, so we'll get started. We'll have a 3-minute speech on the affirmative, and then a question period if you'd like to ask questions, and then I'll give a 3-minute speech. So, all right.
Okay. So, let me take off my jacket. Okay. Well, hello everybody. My name is Aaron Hill, and to tell you the resolution once again, the resolution is as follows: social justice movements should adopt interest convergence as their primary strategy for promoting criminal justice reform. Now, I believe that it should be the primary strategy for social movements. Why I believe that is because I believe it's the most practical. As we say, we can all probably agree that ideally, laws should be reformed as soon as we are made aware that they facilitate oppression and inequality. However, the history of legal reform suggests that such sweeping reforms are met with hostility and backlash. The affirmative team wishes that this wasn't the case. However, we recognize that if we want to take any steps toward equality of the races, we must be realistic and take baby steps until we reach our end goal. To give you more of a historical example, I will cite Brown versus Board of Education. It was a landmark decision that, one, the court case was monumental in its ruling, and two, however, the ruling itself did not generate immediate results. It had many backlashes, such as busing, and further down the road, it caused more segregation in schools. But it was still the first step necessary in order to get African Americans into certain schools. In order to give you also a more figurative example, it's almost like the game of baseball. Someone has to swing in order to get on first base. And then if you have the chance, you can go to second, to third, and then finally score. And in the modern scenario, in the realistic scenario, it would be making a change. And that is what we all are here for. Changes take risks. Changes take time. Changes take effort. But it will all be worth it in the end because we did something that was never ever seen in this world. So that is why I'm affirming Derek Bell's notion of of interest convergence theory, because through this we are able to all come together in order to create the change. We may all have different goals or viewpoints in mind, but if we can all create a change that we're all happy with, I agree that's for the best. Thank you.
So does anyone have any questions? I mean, if not, I can just go. We'll speed it along so you can get to it. All right. All right. So I am arguing on the negation that this should be our primary tactic. And so the affirmative side, the opposition, brought forward this point that with Brown v. Board of Education. So in the United States, our criminal justice system is facing a lot of problems, specifically when it comes to race. 1 in 3 African-American males are expected to be incarcerated in their lifetime now in the United States. It's 2.3 million people are incarcerated currently in the United States. Over half of that, or almost half, are African Americans. So the problems that we face are very race-based. So that's where Professor Bell, who's actually an undergrad at Duquesne University, Professor Bell proposes this theory, and he specifically looks at Brown v. Board of Education in this very particular instance. The problem that I have, arguing the negation is that this theory worked for this one particular case, but at one particular time. I believe that it shouldn't be our primary strategy because it actually had drawbacks. So, for example, in looking at Brown v. Board of Education, it supposedly ended school desegregation in the United States, but in fact, the United States school system is still very much segregated. Private schools are still predominantly white. Urban city schools are predominantly African American. So, sure, Professor Bell argued that African Americans in the minority had an incentive to come to the negotiating table with whites in the majority to pass this case or for the Supreme Court to side. But using this theory, sure, it worked in this one particular case, but in the long run, it actually didn't work. So that would be my first point, would be that it's actually a drawback with the theory. Therefore, because of this drawback, and it only worked in one particular case, making it our primary strategy for criminal justice reform isn't in our best interest. Second, I'd like to talk about kind of the dual groups in the United States right now and focusing on the issues of race, specifically looking at the criminal justice system. It's Black Lives Matter and then a group called All Lives Matter, and both of whom are arguing two different sides of this narrative of race relations in the United States dealing with the criminal justice system. So my argument is that if we adopt this as our primary tactic, that's like telling Black Lives Matter that, yes, you need to conform to the majority who would say all lives matter. So this isn't an exact strict, like, the minority is Black Lives Matter, the majority is all lives matter, but it's just talking about kind of the dichotomy of the two groups. So we believe, on the negation, I would argue that it dilutes the importance of a social justice movement. So if a social justice movement, it needs to have this oppositional consciousness where they're able to develop their voice. Martin Luther King argued this most, that negotiation comes later. In fact, disruption, making sure that the white majority understands that there is a problem within the African American minority, that must come first. So that's what I would argue on the negation, that this is certainly a tool. It should be utilized down the line. But for right now, let's not dilute the matter. Let's focus on Black lives. Let's understand that African Americans are in the minority and they're being oppressed, and to really put forth this criminal justice reform, the disruption, this oppositional consciousness, the use of these social justice movements like Black Lives Matter working toward justice is better right now in this stage, but coming to the negotiating table so soon would not be in their best interest.
Across the head.
Yeah, that's fine.
Okay. Oh, you want to just do it?
If you want to ask, that's perfectly fine.
Okay, let's just address your school segregation point, correct? You said that schools are still segregated, correct?
Correct.
So you're saying do minorities still not have access to those schools?
I would argue that minorities do not have access to private schools, mainly because they're socioeconomically isolated in urban cities. They do not have the resources to send their children to private schools who happen to be predominantly white.
But in public school access, though?
Public school access, all people theoretically are able to go to a public school, yes.
Okay. You say Black Lives Matter is, if we did interest convergency, it would dilute their
Yes.
movement, correct?
Yes.
Now, can we both agree that Black Lives Matter is a heed or a call to the government saying that you need to pay attention to Black lives because you seem to be forgetting? Can we agree on that?
Certainly, yes.
Okay, so great. So would you call that interest convergence because Black Lives Matter is trying to appeal to the state that these lives need to matter?
No, I would not. And I would say why is because I would take the model of Dr. King, and when he looked at, you have to focus on nonviolence disruption first, and then come to the negotiating table. So in your case, Black Lives Matter would form this group and then immediately go to the government, sit down with President Obama and say, we need to do X, Y, Z, come to a compromise. My argument, that would be interest convergence theory. My argument on the opposition would be that we have to first make sure the majority understands they're a problem, that'd be number one. And then second, in putting on like this pressure, we need to let these social movements grow. The fact of the matter is the civil rights movement took 2 decades to grow into as powerful a movement as it is. If you go to the negotiating table right away, you lose a lot of the leverage. I think building this oppositional consciousness, this radical edge that social movements have, like Malcolm X and the voice he had in the civil rights movement, it's very important.
Okay. Now, I don't know how much I can go. Keep it. We can end it.
Yeah, you can if you want to do one more.
Okay, there's one question. Would you call it disruption influencer?
No, I would not. I would not say it influences as much as it does call attention to.
Okay. Alright. So one section.
Oh, that's it. We don't have any two.
Oh, I'm sorry.
That was a cordial debate.
You want to do the end poll?
Oh yeah, we do. Okay, we'll do an end poll. All right. So, all right, ending poll. So, who's still in favor of interest convergence as the primary tactic? Against it? Thank you. I won.
So speaking now is Zola Phillips from University of the West Indies, and she'll be speaking on being a witness in Trinidad and Tobago, a qualitative case study on the nature of witness care in the criminal justice system in Trinidad and Tobago.
Thank you.
I'll speak right there with the time cards.
Okay, good afternoon, everybody. My name is Zola L Phillips, and I will be presenting to you today on my topic, witness care. I want to thank the organizers of this conference for the opportunity to present. I am a PhD student with the University of the West Indies, and what I'm presenting to you is a thesis in progress. So I'm at the introduction chapter, which is chapter 1 of 6. So I hope you enjoy, and let's go. Slide. My title is Being a Witness, a qualitative case study of the nature of witness care in Trinidad and Tobago. My main objectives today is to give you an overview of my study, and then I also hope to get some helpful feedback. My presentation will start with a look at the background of my study, the operational definitions, then I will go into my background, and I'll end with some limitations and delimitations. I start with operational definitions because it is important that these points be clarified so that any ambiguity of terms can be clarified, and also to begin to set the study in the unique context of Trinidad and Tobago. According to Section 118 of the Criminal Code of Canada, a witness is a person who gives evidence orally, under oath, or by affidavit in a judicial proceeding. The witness can be a child who provides a testimony under specific circumstances, or witnesses may include anyone who actually sees or hears a crime or an event related to a crime. For example, the investigating police officers or experts regarding a relevant topic pertaining to crime. For example, coroners, ballistics experts, or a forensic psychologist. My second term, witness care. This witness care definition is taken from the British model of the program, which will be used throughout my study because they are the stars or leading group in this field. Witness care refers to a program specifically developed and dedicated to the end-to-end support of witnesses from the time a report is made to the verdict being read. The program ensures that witnesses have consistent access to a witness care officer who can give them information regarding their trial or court operations. Timely updates can also be provided about schedule changes, and a needs assessment, which is carried out at different points of the trial, is done to ensure that the witness's unique concerns are resolved. Witness protection, which is referred to in Trinidad and Tobago as justice protection, is the protection of witnesses, usually by the state, from the imminent or perceived threat of death. These persons are removed from their homes and neighborhoods and relocated to new local areas, or sometimes taken out of the country, depending on the resources available and also the level of threat. Finally, victim and witness support. Victim and witness support refers to a unit existing and operational currently in Trinidad and Tobago. However, it differs a lot from witness care, and I'll tell you why. It caters mostly to victims of sexual assault and domestic violence. The victims are identified either upon making a police report or by calling the unit directly for assistance. They receive intervention through counseling support and are referred to other necessary facilities if halfway housing or medical care is needed. Slide. Thank you. Slide again. Okay. My study places the case of witness care in the unique context of the Republic of Trinidad and Tobago. In this twin island state, Trinidad is 4,828 square kilometers, and Tobago is 300 square kilometers. Tiny. The population based on the 2015 census is 1.35 million, of which 95.72% are located on the island of Trinidad. 50.2% of these persons are male, and an estimated 70.6% of the population is between 15 to 64 years old. The country is rich in oil and gas, which is where the majority of their revenue is generated, unlike most Caribbean islands whose income is grounded in tourism. Trinidad and Tobago is still just as beautiful, though, with Tobago winning the Eco-Tourism Destination of the Year award for 3 years in a row. Trinidad and Tobago is located at the southernmost point of the Caribbean chain of islands. This chain of islands stretches from the coast of North America to the tip of mainland South America. At its closest point, Trinidad and Tobago is only 7 miles, which is 11 kilometers, off of Venezuela. Trinidad and Tobago's close proximity to South America has facilitated its involvement as a transshipment point for drugs such as cocaine and heroin, destined for the United States and Europe. According to the United States Drug Enforcement Agency, the amount of drugs arriving in the USA being trafficked first through the Caribbean has almost doubled since 2012. Trinidad and Tobago also acts as an origin and final destination point for the drug marijuana and also for human trafficking. That's why I call it a hotspot for trafficking. Slide. The overall crime rates in Trinidad and Tobago are high. Reports show that the country has one of the highest murder rates per capita in the world. We are actually ranked at 10th place. The 2012 murder rate was 37.9 per 100,000 people, which equates to 379 murders for that year. In 2013, there were 407 murders. In 2013, 407 murders. In 2014, 403. In 2015, 410 murders, and for the year thus far, we have 357 murders in Trinidad and Tobago. The year 2008 still holds a record high of 550 murders. The murder rate, The murder rate continues to be driven primarily by gang and drug-related activities. Sexual offenses have seen a steady increase from 692 in 2008 to 1,020 in 2012. Many crimes go unreported in Trinidad and Tobago. According to Senior Counsel Dana Sita Hall, who is head of law fraternity in Trinidad and Tobago, she's deceased, in a Guardian newspaper interview, this is largely due to a lack of confidence in the powers that be, such as the police and government, as some citizens believe that they are generally corrupt and prove ineffective in their ability to solve crimes. Citizens who are wronged either stay quiet for fear of further victimization, engage in vigilante justice, which is the norm among all gangs, or they leave the country if they can afford it, as such support services and evidence tend to be unavailable. Of these crimes reported, the majority occur within the metropolitan areas of Port of Spain and San Fernando. According to the Overseas Security Advisory Council, 2015, 23% of reported crimes in Trinidad and Tobago result in arrest. These low rates are mostly due to a lack of evidence. The conviction rates are even lower, with a 5% conviction rate for murder, 17% conviction rate for manslaughter, and a 1% conviction rate for gang-related murders. Police investigations and criminal trials depend heavily and sometimes solely on eyewitness testimony. Dr. Randy C. Prasad, leading criminologist at the University of the West Indies, was quoted as saying that although the Crime Procedure Act makes provisions for the compensation of witnesses, it is far from adequate. He went on to mention that the non-appearance of witnesses often makes criminal cases invalid and ultimately a mistrial due to this lack of evidence. The article further highlights that witnesses do not present for court due to various reasons, such as persons believe that this is a waste of time since they do not have faith in the ability of the criminal justice system to ensure justice is served. They have been intimidated sometimes by the defendant or friends of the defendant because of these no-snitch codes or some other community loyalty. Sometimes they do not understand the criminal justice system procedures, and some still cannot economically afford to be an eyewitness because it is, in their words, an inconvenience and financial burden, as it can be costly for transportation, to arrange time off from work, and at this point they sometimes risk losing jobs or wages. It is also sometimes complicated to arrange childcare and sometimes even food and clothes for court. In instances where witnesses are present for the trial, they may not be cooperative and deemed therefore as a hostile witness, unable to provide an accurate account of the incident. When trials go on for months and even years, witnesses become disenfranchised and find the experience taxing both physically and psychologically. Slide. No witness, no justice. The United Kingdom started the slogan, "No witness, no justice," to highlight and raise awareness and concern for witnesses. Eyewitness testimony is an important aspect of investigations and court trials. Several crimes may be committed at any point in time. However, many of these crimes go unpunished due to a lack of evidence. It is a fact that without witnesses, there is no justice. First world countries, as well as some other Caribbean islands, Barbados, St. Lucia, Bahamas, and even Belize, have started the criminal justice reformation process to move away from an offender-centered system to one that is victim and witness-centered, so that all parties are helped through the harm or hurt of crime, and also because the authorities have acknowledged the importance of witnesses to criminal justice system operations. Persons become witnesses. The Criminal Procedure Act of Trinidad and Tobago, Section 16 to 28, Chapter 1202, is where one would find all the litigation there is regarding witnesses. The first one speaks to attendance of witnesses. Section 16 says, every person who is bound by recognizance to attend any criminal sessions as a witness, whether for the prosecution or for the defense in any case to be tried at such sessions, shall be bound to attend the court, whether or not he has received any subpoena or notice on the day appointed for the trial of such case, and on subsequent days of the sessions until the case has been disposed of, or until he has been discharged by the court from further attendance. This continues on for another 4 paragraphs, speaking on what will happen to a witness who does not attend court as they should. Later on at section 26, they touch on expenses of witnesses. It says, where any person appears before the court on recognizance or subpoena by virtue of a warrant to give evidence against any other person accused of an offense, the court may order payment of the costs and expenses of such witnesses together with the compensation for his trouble and loss of time. This again continues, however, nowhere in the law it actually states to the maximum that can be paid to witnesses, but I went to the court myself to find out, and the maximum figure since 1925 has been $50 TT, which equates to less than $8 US. Thank you. The current witness care system in place in Trinidad and Tobago is informal and relies on the altruistic nature of law enforcement and lawyers to inform and support witnesses where possible. There are no explicit regulations or policy to assist witnesses in the criminal justice system, so witnesses are not continuously supported throughout the trial, if at all. The system is fragmented and leaves most witnesses vulnerable. My study seeks to explore the nature of witness care in Trinidad and Tobago from the perspective of key stakeholders such as judges, magistrates, lawyers, police officers, criminal justice administrators such as the Director of Public Prosecutions and the Chief Justice himself. Most importantly, I also interview some witnesses. This study will focus on adult witnesses. It will seek to garner information on the type of care that they receive and support that is provided, how it is provided, and who provides it for the countries, for the witnesses, before, during, and after a trial. My research questions are, my main question, what is the nature of witness care in Trinidad and Tobago? The sub-questions are, how important are witnesses to the criminal justice system of Trinidad and Tobago? How are witnesses currently cared for? How can witness care be monitored or evaluated? And how would specific legislation for care affect witnesses? The study is significant to persons working in the field of criminology and criminal justice in Trinidad and Tobago because it will improve their understanding of witness expectations and needs, as well as grant them an opportunity to improve the service they give to witnesses. Students and faculty of criminology will also find the study informative as it will shed new light on this phenomenon. It is important to the persons in the larger society as it will provide more opportunities for sound trials and efficient justice. It will also improve police-community relations as faith and trust is built from these interactions. Some limitations for my study so far. The timeline expanded. The estimated timeline for completion of all 38 interviews was 2 months, which ended up being 6 months due to hectic schedules and other such changing factors of the persons I was interviewing. Interview venue also changed due to the availability and comfort of my interviewees, which sometimes meant that persons walked in and out of their offices, and there were other distracting noises which made audio recording very difficult. There's also a lack of resources or primary resources on the topic of witness care in Trinidad and Tobago. So I have had to use a lot of secondary sources, newspapers, etc., which is a strong source of information for research in my country on this topic. Slide, right. Delimitations, the term witnesses in this study solely refers to adult civilian citizens who are also lay members of society who possess information regarding a crime. They differ from expert witnesses who are professionals and testify in court based on their expertise. Witnesses in my paper also will differ from child witnesses who are persons under the age of 18 who may require parental or guardian consent or accompaniment to court. And finally, they also differ from vulnerable witnesses, which refers to persons who are physically or mentally ill or challenged. Persons being interviewed are restricted to witnesses, police officers, attorneys, and other criminal justice system administrators. I have not looked at any prison officers or any other facilities, as the focus is for persons who interact with witnesses on a daily basis. My study, finally, is a qualitative research, because qualitative research facilitates the exploration of a phenomenon within its context using a variety of data sources. I chose qualitative research so I could fully explore the phenomenon of witness care. In-depth questions needed to be asked, so a survey or questionnaire would not be ideal. Cresswell 1988 suggests that the qualitative research paradigm should be undertaken when the topic requires exploration due to a lack of theory and when research questions begin with what and how. And that brings me to the end of my presentation. Thank you very much for listening. Are there any questions or comments?
I actually have a question. So the criminal justice system and lawyers and courts are agents of the state.
Yeah. Yes.
What's the concept in Trinidad and Tobago of the state's role in providing services for its citizens? So what is expected of the state as far as, we'll take care of you?
So our criminal justice system at the moment is solely offender centered. So as far as providing services to other parties engaged, there's no policy regarding it at all. The state is not responsible at the moment. What recently came on board was the Victim and Witness Support Unit that I mentioned in my operational definitions. And this unit actually works out of the police service, the TTPS, and they brought psychologists on board to work with them so that persons who come in and report domestic violence or sexual assault can have someone there to intervene, provide that counseling support that they may need before they go back to the police service. At the moment, everyone else is winging it on their own, for want of a better term. So that's why I'm trying to raise awareness about the need for such a service for witnesses. Yeah. Thank you. Any other questions?
Were there any high-profile cases of witness intimidation or anything like that?
Yes, there are several. I didn't mention them here, but over the past 5 years, from news reports only, there are over 10,000 cases where witnesses did not come forward or were so intimidated or turned up dead due to their testimony or pending trials. So I plan to use some data from that to support my argument for witness care. Again, our Justice Protection Service, which is like your Witness Protection Service, is it's in existence. How functional it is at the moment is also a question that I have. But my study is focusing on the care of witnesses, which does not include their protection from imminent danger. It is more about their emotional and psychological well-being, and also to provide them with information regarding their trial, basic information. Any other questions? Any comments? Okay, if not, I thank you all for being here and allowing me to present for you. Have a good afternoon.